Citation in the matter of Stellantis N.V. and others, and NTN Corporation and others.
And only expressing provisional views of the court. We're minded to give permission because of the importance and seriousness of the issues in the case, although that is not in any sense to be taken as an indication as to what we think the result of the appeal might be after we've heard full argument. But just because it may just save some of the argument about the test and so forth. All right? Yes, Mr.
Well, I'm very grateful for that indication. Well, for the record, I appear with Mr. Thomas for NTN, the appellant. Ms. Ford, King's Counsel, appears with Mr. Wolfe for respondent.
We've got a transcript, haven't we? So.
Lord, as far as I know, yes.
Yes. No, I'm only asking so I don't have to write furiously every single word you say, Mr.
Well, I will be offended if you do. My Lord, your indication at the outset has simplified my roadmap for this morning. I wish to address 2 points, if I may. First of all, very briefly, the context and importance of this appeal for NTN, and then I will give priority to ground 1 and more briskly to ground 2, and at the risk of confusion, with your Lordship and your Ladyship's permission, I will deal with grounds 4 and 3 in that order.
Okay.
And my Lords, I don't think this is an important point, but it's a relatively short point, and I hope my submissions can be completed pretty briskly, I hope. Less than 90 minutes, subject, as always, to questions from the bench. So, Lords and Ladies, this appeal is fundamentally important for NTN. FCA claims damages of a total of almost 100 million euros, including interest. The trial in January is scheduled to last for 5 weeks, with heavy evidence on statistical econometric analysis in particular. NTN puts forward 3 lines of defence. The first is that the competition law infringement did not cause prices to rise any more than they would have in the absence of the infringement. So we say there was no overcharge in the case of FCA. Second, we say that even if FCA can prove an overcharge in its case, FCA suffered no loss because it passed on and mitigated and abated its loss in the form of price increases to its customers, who in the first instance were the dealers. So if there was an overcharge, its incidence fell elsewhere, we say. So this is our first mitigation defence. It concerns the pricing of FCA's outputs. Finally, we have a second mitigation defence, which is that any increase in the cost of bearings caused by the infringement led to FCA seeking an offsetting cost reduction from its other input suppliers, with the result on a net basis that FCA suffered no, or at least reduced, loss. This concerns how FCA dealt with cost inputs in the context of the infringement. And the second mitigation defence is potentially a complete defence in the context of an enormous claim for damages in complex litigation. And yet the CAT found that we cannot even argue a trial, and despite not having disclosure on any of the issues to do with the second form of mitigation. And it is the second mitigation defence which is the subject of the appeal before the court today. A couple of final points. This appeal is also important, as the Chancellor noted, for many other claims and third parties. As Lord Justice Green noted in response to the application for permission to appeal, the mitigation defence at the heart of this appeal has been pleaded in many other pending cases by defendants before the CAT on the High Court. And indeed, as the court may have picked up from the papers, in the trucks proceedings, where FCA faces multi-billion-pound claims as defendant, FCA itself has pleaded a mitigation case based on cost reductions in much barer terms than NTN did. And if the CAT judgment stands, FCA's defence in that case cannot possibly survive either, since unlike our pleading, it is pleaded in purely formulaic terms. Now, our central criticism in this appeal is that a mitigation defence that the Supreme Court has held in interchange is in principle a good defence, has been made subject by the CAT to a series of preconditions or assumptions that in practice are so limited to render it vanishingly rare that it can actually be relied upon. In this way, the CAT has effectively neutered what is in principle a valid defence. We say this is a wrong approach. Matters of causation are matters for trial, save in the most obviously hopeless of cases, of which this is manifestly not one. And well, Lords, I turn to the second part of my submissions, the individual grounds, starting, if I may, with ground one. The first ground concerns the CAT's findings on ordinary budgeting control, giving rise to a general presumption that there will be a lack of sufficient causal nexus or connection between the overcharge and the steps taken in mitigation. If I can quickly pick up on the key findings the CAT made in this regard, core bundle tab 9, please. It starts at paragraph 20. Internal page 76. And they say, if a defendant can only point to what might be regarded as ordinary financial operations budget control process, this will generally be insufficient to establish the necessary connection between overcharge and relevant steps. And then it goes on, a defendant who only points to ordinary operations and processes for controlling costs is unlikely to demonstrate a realistic prospect of succeeding in trial, showing proximate causation. And then finally at 29, on page 80, there was no suggestion in NTN submissions that the setting of targets can be regarded as being in any way an unusual business approach. In our view, it clearly is not. It is an ordinary and run-of-the-mill budgetary control process, and so on. As an ordinary budgetary control process, which operates independently in ignorance of the overcharge on bearings, the necessary linkage between that process and the overcharge is absent and certainly implausible, at least unless there are some particular facts which could plausibly give rise to the inference that the necessary causal connection existed. So we say it is clear that the CAT has put forward as a general matter a principle that ordinary budgetary controls would not suffice for purposes of this mitigation defence, and that was fundamental to the CAT's reasons for acceding to the strikeout application. And we say the CAT made a fundamental error of principle in reaching that conclusion. Can I just give the court the headline points and then develop them very quickly? First, the overarching point of principle is that competition law damages are compensatory only in nature. This is a trine proposition. We say the CAT has lost sight of it here. Second, the Supreme Court in the interchange case, which the Chancellor will be very, very familiar with, has confirmed, first, that mitigation is available as a defence in these kinds of cases, and second, it is in principle a mitigation defence if the claimant has reacted to a cost increase caused by the infringement by seeking offsetting reductions from its other suppliers. Third, in that context, and contrary to what the CAT found, the Supreme Court made crystal clear that ordinary budgeting controls would be, in principle, sufficiently proximate as a matter of causation. Of course, the facts have to be established at trial, but in principle, the link of proximate causation was satisfied in the case of ordinary budgeting controls. So the only relevant question is whether the claimant has in fact suffered a loss. If it has not, that is the end of the matter, we say, and it is irrelevant that the mechanism by which the loss was mitigated was an ordinary budget control mechanism or some other mechanism.
I suspect it's only that latter proposition that is controversial here, whether sufficient budgetary controls are sufficient to be proximate. I mean, I suspect everything else is common ground, but that, I think, is the controversial issue here.
Oh, yes, your Lordship is quite right. I'm teeing up the sequence to hopefully narrow the issues in dispute. I'm grateful. So we say what matters is that the loss was in fact mitigated. And we say the CAT erred because it lost sight of the basic principles of compensatory damages and instead got distracted with the semantics of whether the mechanism in question by which the loss is mitigated was ordinary or, by contrast, unusual budgeting or other steps. We say this is wrong as a matter of law, since an ordinary business process can be sufficient in itself to establish causation without any additional factors being shown.
Isn't it the fact that it's not the fact that it's an ordinary budgetary process, if you read 29 carefully and fully. It's the fact that it operated independently. I mean, leave to one side the point about in ignorance of the overcharge. I mean, I know you have submissions to make about that, but it's saying it operated independently. So in other words, there wasn't a linkage. So it wasn't a case where that's what the CAT found, where there was any arguable causal connection. So it's not so much that it's an ordinary budgetary process, it's the absence, it's the fact that it operated independently. That's how I read it anyway.
Well, your Lordship is correct, but what I will show the Court immediately now is that in interchange itself, the Supreme Court made very clear that if in fact the loss was mitigated through an ordinary budgeting process, in principle, that is a sufficiently proximate form of causation.
You've just said, if in fact it was. So the in fact is the controversial bit here.
Yeah.
If you have an ordinary budgetary process which does in fact mitigate one way or another, then obviously that's mitigation and compensatory principle bites and you don't get it. But if it doesn't in fact...
Although if we can quickly go to interchange...
A classic example, I mean, it would be one of the ones that's posited by the CAT in Royal Mail, which is where the claimant discovers that in fact he's being overcharged for something and decides to compensate for the overcharge by reducing his costs elsewhere.
Yeah.
So that's a classic case in which you can be said, well, you've mitigated your loss, so in truth you haven't actually suffered the loss at all. But that's where, as my Lord says, where there is in fact a causal connection. Now, I follow your point. You say, well, we should at least have the opportunity to argue it at trial.
Yes.
Because this is all turns on the facts. But the question for us is whether you, as it were, fail at the first hurdle because you don't even get to arguability.
Although we say on the basis of a particular interchange.
Do you want to look at that?
Oh yes, I know the Chancellor will be familiar with this. It's in Authorities 10. We don't, I think, need to detain ourselves with a lot of factual detail. I mean, the headline point we can see in the heading of 216 is there was a cooperative effort between the banks to put together an offer to merchants a payment card system, and in the context of that system, a particular charge made up of two components, a multilateral interchange fee, the MIF, was charged to the acquirer, in turn passed on the cost to the merchant through a merchant service charge, the MSC. So these two components were the interchange, and they were the input costs passed on down the chain. Now, the judgment deals with a range of different issues. We're only concerned with the mitigation part, which starts at 175.
Paragraph 175.
So the narrative mitigation point, as you can see in 175, was about the degree of precision needed for pleading a mitigation defence, and in particular a pass-on of the overcharge. And then at 176, you can see the Court of Appeal rejected the broad acts principle as applying to mitigation. And then at 226, the Supreme Court says, we We do not interpret the Court of Appeal as having held the defendants had to prove the exact.
Sorry, which paragraph was that?
My Lord, 226.
226. 226.
We do not interpret the Court of Appeal as having held the defendants had to prove the exact amount of the loss mitigated. So far as the Court of Appeal required a greater degree of precision in the quantification of pass on from the defendant, the claimant, the court heard. So that was the narrow mitigation point. But in the context of deciding that particular point, the court made a wide-ranging series of findings on questions of mitigation more generally in these kinds of cases. And it is to that I now wish to turn. 181, you will see.
The actual point on the appeal there was the degree of precision that was required.
Yes. Okay. Your Lordship's right, and they held what sauce for the goose is sauce for the gander. That the degree of precision should be symmetric.
So, which paragraph do you want us to look at?
Well, 181, you see the court's roadmap for the issues it looks at. So first, requirements of EU law. Second, burden of proof. Sorry. Second, entitlement to law. Third, burden of proof. And fourth, the degree of precision. And I can take the remaining references quickly. So 189, my Lords, my Lady, if I may. They say, it is therefore a question of fact in each case. The national court must resolve on the evidence adduced before it, whether an overcharge resulting from breach of competition law has caused the claimant to suffer a loss, or whether all or part of the overcharge has been passed on by the claimant to his customers, or otherwise.
So, I'm sorry, Mr. O'Donoghue, I've lost the paragraph number.
My Lord, forgive me, it's 189.
189, thank you. Yeah. Okay.
So, question of fact in each case, passed on or otherwise mitigated. Then we see at 194 reference to the compensatory principle, which they rightly regard as trite law.
Yeah.
And then 196, the normal rule of compensatory damages applies to claims for breach of statutory duty and no entitlement to treble damages and no exclusion of the pass-on as an element of damages in the way, for example, occurs at a federal level in the United States. And at 197, there are sound reasons for taking account of pass-on in the calculation of damages breach of competition law. Not only is it required by the compensatory principle, but there are cases where there is a need to avoid double recovery through claims in respect of the same overcharge by a direct purchaser and by subsequent purchaser, the chain to whom an overcharge is passed on in whole or in part. Now, my Lords, my Lady, pausing there briefly, 3 points come out of that. First of all, the direct purchaser only has a claim if he has suffered a loss. That is the compensatory principle. Second, it is fundamental that pass-on can be argued by a defendant, because if not, there is a risk that the defendant has to pay the same damage twice to both a direct and indirect purchaser. That is the double recovery point, which is the corollary of the compensatory principle. And third, mitigation is not merely a shield for a defendant. It is also a sword for an indirect purchaser, since for the indirect purchaser to establish a claim, must be able to show that the loss was passed on by a direct purchaser to the indirect purchaser. And we see this point picked up expressly at 220. It's at G, so reference to the damages directive. Pass-on may be invoked by an infringer as a shield against a claim for damages, and by an indirect purchaser as a sword to support an argument that it has suffered harm. Then, my Lords, my Lady, we see 225. The Supreme Court moves to the specific question of mitigation. And it says, in the present appeals, the merchants, by paying the overcharge in the MSC, have lost funds which they could have used for several purposes. As sophisticated retailers, which obtain their supplies from many suppliers and sell a wide range of goods to many customers, they can respond to the imposition of cost in a number of ways. One is do nothing. 2 is reduce discretionary expenditure. 3 is this case, reduces cost by negotiation with its many suppliers. And 4 is the classical pass-on defence as a second form of mitigation. And then 206, in our view, the merchants are entitled to claim the overcharge in the MSC as the prima facie measure of their loss. But if there is evidence that they have adopted either option 3 or 4, or a combination of both, to any extent, the compensatory principle mandates the court to take account of their effect. It will be a question of mitigation of loss, to which we now turn. So if the claimant reacts to a cost increase caused by an overcharge by seeking to reduce its costs by negotiating with its other suppliers, the compensatory principle requires that to be taken into account. And we say this is the key error which has been made by the CAT. If in fact the claimant has reacted to a cost increase caused by the infringement by then forcing its other suppliers to reduce their costs, the Supreme Court says that the compensatory principle mandates the taking into account of this mitigation. It is irrelevant in this context that the particular mechanism by which the mitigation occurs is ordinary budget controls. What matters is that in fact mitigation has occurred to mitigate any loss. And the Supreme Court in my submission makes this crystal clear at 215. So what was, just to back up, so they say 212, there are obviously legal principles about additional benefits in the context of mitigation. And at 214, there are separate legal principles or related legal principles about a failure to act reasonably to mitigate. And they say 215, we're not concerned in these appeals with additional benefits resulting from the victim's response to it, which was an independent commercial decision, or with any allegation of a failure to act to take reasonable commercial steps. The issue of mitigation which arises is whether in fact the merchants have avoided all or part of their losses. In the classic case of British Westinghouse, Viscount Haldane described the principle: the claimant cannot recover for the avoided loss in these terms. When in the course of his business, the claimant has taken action arising out of the transaction, which action has diminished his loss, the effective actual diminution of the loss he has suffered may be taken into account. Here also a question of legal or proximate cause arises, as the underlying words show. The question of legal causation is straightforward in the context of a retail business in which the merchant seeks to recover its costs in its annual or other regular budgeting. The relevant question is a factual question. Has the claimant in the course of its business recovered from the others the cost of the MSC, including the overcharge therein? The merchants, having acted reasonably, are entitled to recover their loss if the court were to conclude the evidence that the merchant had, by reducing the cost of its suppliers or by pass-on of the cost to its customers, options 3 and 4 in paragraph 205, as we saw, transferred all or part of the loss to others, its true loss would not be the prima facie measure of the overcharge, but a lesser sum. And there really is no doubt about ordinary budgeting processes being within scope for causation purposes, because if one goes to 225, page 278, they say the loss caused by the overcharge, the MSC, was an increased cost which the merchants would in all probability not address as an individual cost, but would take into account along with a multiplicity of other costs in developing annual budgets. And they say the extent to which the merchant utilised the options can be a matter of estimation. In accordance with the compensatory principle of proportionality, the law does not require unreasonable precision in the proof of the amount of the prima facie loss which the merchants have passed on to suppliers and customers. So we see multiple references to ordinary budgeting processes in principle being capable of being a causal mechanism. They are not independent. In the light of this ruling from the Supreme Court, we say it was extraordinary that the CAT should conclude on a strikeout basis that NTN's case could not even go to trial or indeed even receive disclosure. And indeed, one of the striking features of the CAT's judgment is that it basically makes no reference to the Supreme Court in interchange. Paragraph 2 of the CAT's judgment simply notes that NTN's amendments arose out of interchange. So There's been a manifest failure by the CAT to grapple with these central elements of interchange. Now, there is a further point of principle which emerges from interchange. The Supreme Court said in relation to mitigation that increasing prices or reducing other costs are both forms of mitigation. One concerns output, which is pricing, the other concerns inputs, which is costs. And indeed, in many cases, both forms of mitigation may be present, that they are simply two levers which can be pulled. And the Supreme Court made clear in my submission that the same broad legal framework applies to both. And in the context of the other form of mitigation, where the direct customer passes on any overcharge to its customers by way of a price increase, it would be completely irrelevant whether or not the increase was part of ordinary budget controls or for some other reason. And indeed, in most cases in relation to pass-on, it will only be a function of ordinary budget controls.
There still has to be a causative link, doesn't it? In the sense that, I mean, if on the evidence it was clear that the direct customer would always have increased its costs to the same level as it has done, then it's going to be more difficult to establish that it's passed on these particular overcharges.
Although, in my respectful submission, no. What matters is that, in fact, the cost increase has been passed on to the indirect purchaser in the form
But if the evidence
of a price
were that they were
increase.
always going to increase their costs to the same extent as they did, then doesn't that defeat the suggestion that there's a causal link?
Although, in my submission, because of the compensatory principle, the critical thing would be that the indirect...
They suffer the loss in any event on that example. Now, I agree that's more difficult to establish in the case of passing on. I followed that. But in the case that we're concerned with, of reduction of costs, I mean, if the evidence were that the car manufacturers would always reduce their costs, because that's what they did. They had an entire department devoted to reducing their costs. So the evidence is they would always reduce the costs to the same extent that they did. Then you would fail on mitigation.
Well, I'll come to that particular point, because your Lordship is quite right. That is a point made
I follow your point
made
that
against us.
that's an issue for trial, but if that were the case at the end of the day, then the defendants case on mitigation would fail.
Well, ultimately, yes. But my Lord, at this stage, I'm making a slightly different point, which is, in the context of the first form of mitigation, which is pass-on, all that is happening is that a cost increase occurs because of the infringement, that then leads the direct purchaser to increase its prices to its customers. And in my submission, in the context of that form of mitigation, it would be irrelevant that the mechanism by which pass-on occurred was an ordinary budgeting process. And indeed, in every case that I'm aware of, that is the only mechanism by which pass-on could effectively occur. Because what happens in a typical situation is the direct purchaser's variable costs increase, and the variable costs affect output decisions. They vary with the amount of output. And then what you do in statistical terms, typically, or empirical terms, is you track how the firm reacts to an increase in costs in terms of a pricing reaction to its customers. Now, if in the context of pass-on, whether or not the mechanism was an ordinary budgeting process would be irrelevant, which is my submission. What the CAT has done in this case is suggest that in relation to a second form of mitigation, a reduction in input costs, there is a fundamental difference of principle, that the ordinary budgeting process in the context of the second form of mitigation, at least as a rule of thumb, disentitles a defendant from relying on that form of mitigation. And we said when...
I'm not saying that's an entirely fair description of what the cat said. If you concentrate on the way you pleaded the matter, you start by pleading what I think can be said to be fair, at least the cat assumes a fair factual premises, namely that there was a cost control mechanism which involved targets. And then as pleaded particularly in the voluntary particulars, paragraphs 3, 4, 5, 6 and 7, you set out a series of inferences. In fact, you have inferences upon inferences upon inferences by the time you get to paragraph 7. And those inferences involve going from the existence of a cost control system to the assumption that it would, inevitably, inexorably, have been effective in neutralising the overcharge.
Yes.
And you're saying to us that on the analysis of Sainsbury's, it's sufficient to plead the existence of a system and ignore that it may be a non sequitur, that it was effective. We just don't know. But you pleaded that A leads to B, leads to C, and the ultimate pleaded result is there was no overcharge. I mean, the cat said, well, that's not, as I read it, it's not entirely logical. You can plead the existence of a system, but why does that inevitably lead to a negation of the overcharge? I mean, there are many reasons why it might or it might not, but the logic is what I think the cat was attacking in the pleading. Now, if you say to us, well, Sainsbury's says that doesn't matter.
As a matter of legal causation.
As a matter of legal.
Yes.
All you have to do is to start with the existence of a system, and that gets you, that's your evidential burden met for the purpose of pleading, then fine, if you're right on that. If they're saying, well, we've just got to look at it as a question of logic, look at the pleading to see if it's realistic, then it may be different.
Well, I am making both points for the avoidance of doubt, but in my submission in relation to grounds 1 and 2, what the CAT has effectively held, they said, as a general principle, as a matter of presumption or assumption, the fact that something is mitigated through an ordinary budgetary process is in principle a reason why the mitigation is unlikely to be proximate. So they approach it both at the level of principle of my submission and at the level of fact. And I'll come to the question of fact in relation to grounds 3 and 4, but I'm dealing at this stage under grounds 1 and 2 at the level of principle, which is essentially causation and law. What I'm saying at this stage is the CAT has made an error of principle, because the Supreme Court in interchange, and in other cases I'm about to come to, said that in principle, if the second form of mitigation occurs through an ordinary budgeting process, that is proximate.
But
It is not independent.
You've just begged the question, you say, if the mitigation was caused by, that's an assumption of fact. I mean, I'm going to have a question mark over the logic of the pleading. By starting with the existence of cost control, it does not, as a matter of logic, mean that offsetting was negated.
Well,
it just doesn't know.
I will come to that in some detail under grounds 3 and 4. I'm happy to take things out of sync if your Lordship would find that helpful. I'm entirely in your hands. But at this stage, I'm starting with the points of principle. We say certainly as a matter of legal causation.
If the claimants would always have engaged in budgetary controls they did engage in, then that doesn't negate the overcharge, does it? Because they're entitled to say, well, never mind that we engaged in budgetary control and reduced our costs. That's what we always did.
Well,
And that's what we would always have done.
Oh, yes, that is ground 4. That is the nub of ground 4. I can accept that.
Okay.
Well, I will come to that. If I can just finish up on the question
Sure.
of principle, then I will deal with Lord Justice Green's point on the amendment itself.
We're not giving you much of a chance here, but when you say the point of principle, is this really what Sainsbury's requires us to apply?
Let me say yes.
In that respect, I mean, do you say that Sainsbury's dealt with this point? I know we've obviously seen the structure of the analysis, but when I read it, I got to para 216, and I was then asking myself, what was meant by the word raised in paragraph 216? Legal burden on the operator of the scheme. So that would be the defendant, the card issuer. But once the defendants have raised mitigation in the form of parcel, then there's the heavy evidential burden on the merchant. So this case turns on what's meant by raised. Do you have to show mere existence of a cost control mechanism or something more? Something more causative.
Something causative.
So the question is, what does the Supreme Court require us to apply? Is mere existence enough, or is it mere existence plus some evidence of causation?
Well, the Supreme Court isn't looking at it in terms of pleading, is it? Because you go back to 205 and 206, they're looking at an issue of principle as to, at the end of the day, whether these forms of mitigation would be arguably available at trial, if you like. Because that's why they say in 206 6. If there is evidence that they have adopted either option 3 or 4, or a combination, the court, the compensation principle mandates the court to take account of their effect, and there will be a question of mitigation. So they're not looking at the threshold issue, which the CAT did in Royal Mail and did here, as to how much you need to plead to get into these principles.
Well, we say 215 in particular. So, Lord, it is important. So I took it to 212. So they say this is not a case about independent or collateral benefits.
No.
214, it's not a case about the obligation to take reasonable steps. They make that clear, 215. But they do say the question of legal causation is straightforward in the context of a retail business, which the merchant seeks to recover its costs of its annual or in its annual or other regular budgeting. Then the relevant question is a factual question. Has the claimant in the course of its business recovered from others the costs of the MSC, including the overcharge? So we say that Sainsbury's is a business, of course, which has thousands of products, very complicated and sophisticated business. And what the Supreme Court is saying here is that in the context of that business, which is dealing with many, many more inputs than an FCA, the question of legal causation is satisfied. There is no question of independent other causes coming into play. So we say it as both. We say that the reference to annual or other regular budgeting in 215 and 225 puts this beyond doubt. Whereas the CAT, by contrast, said that, well, if you don't know about the overcharge and you're engaged in ordinary budgeting activities at the level of principle, there is unlikely to be a proximate cause. We say that that is an error of law, even before one gets to the errors in relation to the pleadings. So we do make both points. We say that both in relation to causation in law and at the level of principle and approaching causation in fact as a matter of pleading, the CAT made separate but related errors. And indeed, in my submission, the legal errors are fundamental to understanding the ultimate outcome, because in a situation where the point of departure was that a lack of knowledge of the infringement at the time and implementation of mitigation by way of general budgetary measures, if the CAT starting point was that in general these would not be proximate mitigation, then in some ways it isn't very surprising that they ultimately end up in a position whereby the pleading is not adequate either. I mean, so this in my submission is the original sin, if I can call it that.
Yeah.
Well, a couple of other authorities before I move on to the pleading itself.
Sure.
First, there is the London Underground case, Platt, which is in Authorities 3, or Authorities Bundle, tab 3.
This is the Newberger case.
Oh, yes. Mr. Justice Newberger, as he then was. And we can pick this up on internal page 29, headed Damages Set Off.
Yeah.
So you had two kiosks. The exit closest to one of them was closed in breach. That affected the first kiosk, and what the first kiosk lost, the second kiosk, in terms of increased passing trade or footfall, benefited. So in the middle, Mr. Justice Newberger says, I think subject to any principle of law authority against the proposition, at least if the claimant's claim were based on loss of profit at the kiosk, London Underground would be entitled to require any extra profit claims made at the Bureau to be credited against the loss of profit. The fact that the set-off may call it that, being relied upon as money received by the tenants acting in a different capacity, namely as tenants of the Bureau, does not seem to me to call that conclusion to question. The claimants are the claimants, they're the same people. The fact that a different result might have been obtained if the lease had been taken in the name of another company seems to be irrelevant. One is concerned with the facts as they are, not with the facts as they might have been. So in my submission, what one gets from this case is that what matters is that the loss was in fact offset by gain elsewhere as part of the ordinary business of the claimant. There is no need for a particular or specific business mechanism. And indeed, the claimant in that case actually did nothing at all to respond breach, except by happenstance sell more in the second kiosk. And secondly and finally, in British Westinghouse itself, which is in Authorities tab 2, well, we start at 689. At the top of the page, where it says, subject to these observations, you will see a statement of the compensatory principle. And then the bit marked, but when in the course of his business he's taken action arising out of the transaction, which action has diminished his loss, the effect in actual diminution of the loss he has suffered may be taken into account, even though there was no duty on him to act. And then over the page,
I just wondered if the more, I know that this was the paragraph the Supreme Court, I think,
oh, that's right.
latched onto. I mean, it may be better expressed in the previous paragraph, where where Viscount Haldane refers to pecuniary loss naturally flowing,
Yes.
which also expresses the concept of causation, doesn't it?
Yes. And just to pick up, my lord, your point at 690, the decision illustrates a principle which has been recognised in other cases, that provided the course taken to protect himself by the plaintiff in such an action, as one or two reasonable prudent person might, in the ordinary conduct of business, properly have taken, and in fact did take, whether bound to or not, jury arbitrator may properly look at the whole of the facts and ascertain results in estimating the quantum of damage. Then it goes on, recent illustrations, so on, and then if you see the subsequent transaction, transactions to take into account must be one arising out of the consequences of the breach and in the ordinary course of business. So that is why we say that imposing a general requirement for something other than ordinary financial or budgetary processes, the CAT erred in law. There is no such requirement. What matters is whether the loss is in fact mitigated in the ordinary course of business. The CAT has ignored the central point of principle, the heart of mitigation, and in our submission wrongly focused on the semantics of whether something is ordinary or unusual or extraordinary. And those semantics in our submission are neither necessary nor sufficient.
Can I just ask you what's understood by the term ordinary course of business? You've not pleaded that the claimant was in breach of its duty to mitigate.
No.
And there may be good reasons for that. It might be quite difficult, given that it would you would then assume that a prudent, reasonable business would have acted unreasonably if it failed to take account of a covert secret cartel designed to thwart it. So if that's the case, you're really asking us to say that it's a proper inference to be drawn as an ordinary course of business from something which a prudent business would not do.
Well, to put it perhaps in simpler terms, we say that, I'll show you the pleading and the evidence that has been disclosed. We say that where a business of this kind is obsessing about cost, input, pricing, it's essentially a waterbed that if they perceive, for whatever reason, an increase in the cost of the bearings in this case, they will immediately seek to offset that increase in some other way. That may be by trying to...
But essentially, there's a question of fact there. You've said if they see an increase. If you're subject to a collusive tendering cartel, when you look around the market, all the prices are similar, and you assume that what's coming out through the RFQ system is competitive. That's the nature of a collusive, deceptive cartel. So how would you know? How do you know that you've got to react? How does your waterbedding apply by responding when you have no idea that the price which looks ostensibly to be competitive ain't?
Well, we'll come on to some of the factual details, but the the basic premise is a simple one, which is you have a long-standing course of dealing over decades with these suppliers. You will instinctively understand what is a benchmark for this level of bearing costs. And if you perceive, for whatever reason, that the benchmark has been increased, you will
But
then...
that begs the question with respect, because the whole premise of the secret cartel is that they don't know, and they never did know, because they're always faced with these prices, this level of price. I mean, it may go up, but everybody goes up to the same extent, so they just assume, well, that's what we're going to have to pay for bearings. So your assumption, well, if they perceive, when you say if they perceive that there's an increase, then they will offset it, makes an assumption which is seeking to draw an inference without there being any factual basis for it whatsoever.
Well, I will come on to the factual basis in some detail. But at this stage, it is a simple point, which is that if you perceive that your costs have increased, for whatever reason, you will then directly and inexorably seek to have an offsetting decrease from other suppliers of other inputs. And
Isn't that an unsound proposition? Because you might say you're always, as a business, looking to reduce your costs across the board anyway. The fact that your costs might have gone up in one area just means you'll be saying to yourself, well, we might make a bit less profit this year because the costs have gone up there, because all our other costs are kept as low as they can be anyway.
Well, but that's where the targets come in, which I will come
Then
to.
you might try and pass it on to your customers by
Well,
increasing the price of your cars.
Well,
That's a
yes,
different issue.
but on the question of knowledge, in the context of pass-on, of course, the direct purchaser will equally be ignorant of the cartel,
Sure.
but will unwittingly be passing on the overcharge to the indirect purchaser. So that is why we say the question of knowledge is, with respect, neither here nor
You
there.
can't overlook the coming, Mr. O'Donoghue. That, I mean, you referred us to Sainsbury's, but in the MIF case, everybody knew about the MIFs. I mean, they were out there. They were absolutely, in your face, if I can put it that way. So that wasn't a secret cartel case. That was a case where everybody knew that these charges were being made by the banks, and the question was, did they mitigate that by seeking to either reduce their costs elsewhere or pass those charges on to somebody else? That's a completely different factual scenario to a secret cartel where, by definition, the direct customers don't know that they're being fleeced by the cartelists.
Well, we say no for two reasons. First of all, the essential point is the same, which is the MSC is simply an input cost in the same way as other products purchased by Sainsbury's are inputs as well. And in relation to the point of secrecy, we made this point in our skeleton, but perhaps it's useful to show the court. If we go to the authorities bundle in tab 8, so the point is that for a substantial period of the claim, it was unclear and unknown whether these restricted infringed competition at all. So we can pick this up in 106 of the authorities bundle in tab 8. And there we have a timeline.
It's page.
Well, it's written in tiny font. It's
Sorry, what
It's
page?
the very last page of that tab 8. The schedule.
yes.
Oh yeah, I've got you.
So the court will see that until 2000 and
But this was to do with knowledge of whether or not
Yeah.
they infringed
yes.
the competition, Article 101. This isn't to do with knowledge that the MIFs were being charged.
Well, that's right.
So then the issue is, well, do we pass on the MIFs? And that issue as to passing on the MIFs is not dictated by whether or not they infringe competition.
Well, in this case, likewise, the input price they pay for bearings is a fact of life, and they will have to decide how to deal with that cost within their business. But the point I'm making here is that not only was it unknown until I think 2005 or 6 that the MIFs infringed competition law, but in fact, as you see in the bottom left, for a number of years, these were either exempted or had received negative clearance. So these were on their face lawful for a substantial period of the claim.
I think the first decisions were the early 90s or late 80s, weren't they?
Yes, I'm sure your lordship had a hand in some of that.
But then there were lots of complaints about that, and then it all started brewing up in the late 90s, and everything started to be investigated in the early part of the noughties.
Yes.
But it was always an issue. I remember the British Retail Consortium getting very, very excited about them in the 90s. We understand that the Commission took a more neutral position until the 2000s, but it was always an issue, and it was highly transparent. I think that's one of the key differences. I entirely see the point about breach or no breach. If you know the MSC is going to be passed on to you, you know you've got to respond to it in some way, shape or form. And as the CAT found, there were 4 ways in which it was done. That was a question of fact, one of which was through offsetting. Here, because it's secret, you don't know you have to respond. So there are no 4 ways. You're not responding. You're just doing what generally you think you have to do to keep your costs down.
Well, it is option 3, because the premise of the Supreme Court is dealing with mitigation in general terms in the context of these infringements. What it said is that if you perceive an increase in input costs and you react to that by seeking to obtain reductions in input prices from other suppliers, that is in principle a form of mitigation. And in my submission, the critical thing is what you do in response to the input cost. The fact that you are not aware at the time that the reason for the increase in cost is a competition or infringement, in my submission, is neither necessary nor sufficient.
But you're assuming there's an increase. It may have just been flat. For 7 years, the cartel went on, I think, for 7 years and 2 or 3 months. That was the period of infringement, at least. It may have just been flat. You know, steel prices might have increased. Nothing may have gone down. What is it that triggers in your mind as a purchasing department that you've got to respond in some abnormal way to recover that increment, which is the cartelized increment, that super competitive increment? Your assumption is that the system will automatically cater for it.
Well, my assumption is that an increase in input prices for bearings triggered a reaction from FCA. So what matters in my submission is what did they do as a reaction, rather than were they contemporaneously aware of the reason for the increase. It is a question of fact in line with the compensatory principle. And again, in the context of the second form of mitigation, pass-on, the direct purchaser would be typically completely unaware that it is passing on. And that is why we say, both in relation to grounds 1 and 2, why is it the case that in relation to one form of mitigation, pass-on, the absence of knowledge of the infringement would be totally irrelevant, and yet in the context of a second form of mitigation, in principle could be decisive? We say there is no rational reason why what are essentially 2 levers available to the customer, which are often used simultaneously, should be subject to a radically different set of legal principles. Because what comes out in my submission loud and clear from interchange is that both forms of mitigation are in principle a valid defence, and both forms of mitigation in principle should be subject to the same set of operational principles. And what the CAT has done, which is our grounds 1 and 2, is say that the question of knowledge and or the question of ordinary budgeting controls as a mechanism could make a decisive difference in the form of one mitigation, but make no difference in the context of the other. We say that is unprincipled and illogical. And indeed, it is contrary to the compensatory principle, because the effect of a different set of principles in relation to one form of mitigation will be to deny other potential third parties their claims, to engender double or treble recovery, and to cause a claimant to be compensated for a loss that in fact that claimant did not suffer. So we say that this bifurcation of the principles in relation to the 2 forms of mitigation, which is what the CAT judgment does, would offend the compensatory principle on multiple levels.
I can see the point that if it's the price increase rather than the reason for it which might trigger a response.
Yeah.
And you'll no doubt come to this. Your pleading says that the mere existence of the cost control system leads to negation of the increment, i.e. the supra-competitive overcharge.
Yes.
That doesn't necessarily follow from your proposition.
Yes.
Even if there's a response to a price increase, it's that bit at the top which you say, which has to be fully mitigated by the system.
Yes. Well, that's where the hard edge target comes in. Let me come to the pleadings. I'm conscious I've been ducking your ladyship's questions on this. Let me come to the pleadings. So, in relation to ground 2, we say that the question of knowledge is neither necessary nor sufficient. In the context of the most obvious form of mitigation would be entirely irrelevant. And we do not understand why it acquires the potentially decisive importance the CAT found it acquires in the context of the second form of mitigation. And indeed, for good measure, we say in Sainsbury's itself, for a number of years, not only was the restriction of competition unknown, but these were found to be exempted.
So we can look at the pleading now.
Oh, yes. I apologise for taking so long to
Not exactly giving you a straight run at it, otherwise.
It's rarely the case in my experience.
One of the advantages is a remote hearing system. Judges keep quieter than they do in court.
I couldn't possibly comment.
Right. So do you want us to look at your original pleading?
Well, yes, but let me just tee up
Yeah, sure.
How this arises. So if we can start with the CAT's judgment, it's at paragraph 34 in core 9.
Yeah.
So they say that there's nothing in NTN's pleading or the simple existence of a target as a benchmark which suggests the workforce would not negotiate.
I'm terribly sorry, just which paragraph are you reading from?
34.
34.
Middle of the page.
Great, thank you very much.
There's nothing in NTN's
Yeah,
pleading.
and then they say, my lord, NTN's implicit case, negotiators would not negotiate as hard as they could, would stop once they reach the target. The target operates a cap. So I simply ask you to note here that the tribunal at least accepted that was our implicit case, and they do make the pleading point, which I'll come to. Now, before we turn on the pleading itself, can I just recall one other principle which we've seen in passing in interchange. At paragraph 216 of interchange, the Supreme Court said, in relation to the question of mitigation in the form of cost reduction, there is an asymmetry of information because the defendant will not know anything really in relation to how the claimant reacts to reductions in costs, because that is within the sphere of the claimant. And the Supreme Court noted that it's asymmetry of information in the context of a shifting burden, whereby if as Lord Justice Green has said, the mitigation plea is raised, there's then a shifting burden in the first instance by way of disclosure on the claimant to give disclosure on how it deals with costs internally within the business. So that the point of asymmetry is important. Now, in our case,
And now I'm coming in again. Do you say a shifting burden? You pleaded in paragraph 41C that there's a burden on the claimant to prove a negative. I'm not certain that necessarily follows from paragraph 216. The burden remains on the defendant throughout to prove his defence. There's an evidential burden to provide disclosure.
yes, the legal burden remains with the defendant. Yes.
If the,
Now, in our case, we have had no disclosure on this mitigation defence. And we simply note at this stage, before I come to the pleading, that the Supreme Court in interchange said that the first step involves the defendant setting out his mitigation case against the backdrop of having very limited direct insight into how the claimant deals with other input costs. And the Supreme Court envisages an iterative process whereby the evidential burden will shift between the parties, excepting, of course, the legal burden remains with the defendant throughout. Now, the asymmetry of information point, in a sense, is nothing new. There is other authority. There's a case called Clark, which is in the authority bundle, tab 14, which I won't turn up. And again, it makes a simple point that if there is information which is not within your sphere as a party, there are limitations on what can be required at the pleading stage in terms of having to give direct factual basis for certain matters. Now, just one final point before I turn up the pleading. If we can quickly look at FCA's own pleading in the trucks case, supplemental bundle, tab 11. Now, I'm not making a forensic point that two wrongs make a right. I'm making a different point, which is at the pleading stage before disclosure, there will be real limitations on to what extent the defendant is able to plead prior to disclosure to the intimate operation of cost controls within the claimant. So it's on page 270 of the supplemental bundle. So this is FCA's own pleading of a defence of mitigation in the trucks case. And if I invite you to look at 40.5 over the page of 271, the last two sentences. So 2 points. First of all, at the last sentence, they say, well, we haven't had any disclosure and too many factual and expert evidence. And second, I simply ask you to note that the level of granularity in this pleading compared to our particulars in my submission doesn't bear any serious comparison. But it is simply to recognise the limitations that defendants, because of the asymmetry, face in pleading out these types of mitigation defences. And in that context, something which is also striking is that our mitigation plea, which has been struck out, is pleaded in the very same paragraph, 41C, as the pass-on mitigation plea, which has not been struck out. And if one looks at that paragraph, the level of granularity on the pass-on plea is inferior to the second mitigation plea, and yet the pass-on plea is going to trial, there has been disclosure, and will be evidence. So it is a forensic point, but we do find it odd that the first form of mitigation, which is pleaded in bare terms, will proceed to trial. There's been no attempt to strike it out, and yet the second mitigation plea, which is pleaded out with some specificity, has been struck out. We find that striking and somewhat odd.
You're effectively raising a catch-22 point. You say that in principle, we're entitled to raise mitigation by offsetting, but if we deny the evidence, we can't do it.
Yes, I mean, well, that is a circularity in this judgment, because when we applied for disclosure, the CAT ruled in paragraph 55 of that ruling, which is in, I think, tab 9 of the supplemental bundle. They said, well, but for a strikeout, we would have given you disclosure on the targets and mitigation. And then when it came to strikeout, they said, well, the problem with your pleading is that you have no factual material to make good that part of the pleading. So that is the dilemma.
It arises in other cases. I mean, classically, it arises in minority shareholder claims when you have no idea what the company's information is, so you don't know how to value your shares. And it happens also in IP cases when you're seeking an account. You don't know how much profit the defendant has made. But it doesn't generally mean that you're entitled to plead a case without at least some particularization of quantum or effect.
I accept that, but there are limitations. I accept that.
Well, it happens. I mean, I know pleading in fraud is different, but it happens in fraud cases as well.
It does.
There's an irreducible minimum that you have to plead before you
Yes.
get to the next stage, which is getting disclosure.
Yes. No, I accept that. Of course, in that context, one has to sign a statement of truth. We did in the context of these voluntary particulars. But let me come to the pleading. Just to tee up the chronology, which in my submission is very important to have correct. And I hope this is common ground. So the chronology is as follows. Both FCA and NTN had made some initial disclosure in this case. And that disclosure did not include disclosure on the mitigation defence, which is the subject of this appeal. Then, in the light of the Supreme Court in interchange, we amended paragraph 41 to include a second mitigation defence. And at that stage, FCA actually pleaded back to the mitigation defence and did not seek to strike it out at that stage. Because we had not had disclosure on the second form of mitigation, we then issued an application for specific disclosure, which included disclosure on the issue of FCA's mitigation by reducing other costs. And in response to that application, FCA put in a witness statement on the disclosure issues. And that is a supplemental bundle 10. And if I can invite the court to turn that up, it's supplemental 10, starting, my lords, my lady, 263. Supplemental 10, page 263. So we say that there are two striking features of the witness evidence. First, in 71, the first sentence, FCA admitted that it set cost targets for particular vehicles and particular parts. And if we can then go back to paragraph 59, this is confidential, so I'll ask the...
Sorry, paragraph 59. Yeah, should we read that to ourselves?
Yes, and my lord, there's a bit in the middle which says whether the supplier, so I can ask you in particular to underline that.
Okay.
So we say, first of all, it is common ground there were cost targets, and it is common ground based on FCA's own evidence that these targets included monitoring of cost savings, and that there was a particular management tool or tools which were used for these purposes. And again, that is FCA's evidence in response to the disclosure application. Now, pausing there, we also say parenthetically that on analysis, NTN was not actually relying on ordinary budgetary measures. It was relying on a particular management and procurement tool on costs, targeting, which was then monitored, as we see at 59, by a dedicated internal system within FCA. So to the extent the semantics of ordinary versus unusual matter in this case, which in my submission they do not, we say that on analysis, this was not the annual accounts budgeting. It was a specific cost targeting management tool and monitoring mechanism. Now, the second piece of evidence we obtained in the context of the disclosure application was a small handful of contemporaneous documents on the question of cost targeting. We can see those at 2.6. No, it's the
references to documents.
it's a tab 9. It's I'm sorry, it's written in microscopic. It's 237 tab 9. It's written in microscopic print at the bottom right. So these were disclosed with Ms. Whiteford's witness statement, which we just saw. This was not disclosure which was ordered. This was disclosure they volunteered in the context of resisting the disclosure application. And again, this is confidential, but what we see in 237 is a particular amount in euros as a cost target per vehicle, and then over the page on the right hand side a percentage of supplier contribution towards that cost target. Now, if I can just round off the references, one of the points made by the CAT, I took the CAT to evidence from one of our witnesses on the cost targets, and there was a finding in the judgment, well, we don't obtain any assistance from the evidence of Mr. Linate. And just to give you the the final set of references. So that we can pick this up in tab 13 of the supplemental bundle.
Sorry, tab?
Tab 13, supplemental bundle.
I haven't got tab
Sure, we've got
13.
that.
We end on tab 11.
Let me have- This is a witness statement from Mr. Donati, one of our witnesses. I'm sorry, we thought this had been sent a few days ago, but evidently not. I apologize.
Okay, Mr. Lunati's statement.
Oh, yes. So I took the tribunal to this and they said, well, we don't obtain any assistance from this. So I'll just give you a handful of references. So starting at paragraph 65, you see a reference to annual supplier conventions, and then at 66, it takes the opportunity to let its suppliers know what is expected of them over the coming year. And in the next sentence, what cost reduction targets for the coming year were, strong emphasis on costs. In 68, you will see a reference to supplier scorecards, and then over the page under B, including cost scorecards. 69, a traffic light system. 71, use of external consultants to provide cost breakdowns to both Fiat and its consultants. And 72, reference to a particular cost target. You see the percentage figure there over a number of years. Now, we say this is highly relevant and is bang on point. Now, in relation to the question the court put to me at a very early stage, well, that's all well and good, but if they stopped, your case only works if FCA stops at the level of the target, does not either exceed it or would have done the same thing in any event in the absence of the infringement. Now, we say there are 5 responses to this point. First of all, that is quintessentially a question of fact or trial. It is part of our case that the targets were hard-edged. We say they would have stopped once they hit the target, and we say that is of course disputed. That is a classic issue for trial, independent cross-examination of factual witnesses, and perhaps even experts. And indeed, one of the criticisms we make of the CAT is that they acknowledge in paragraph 33 the targets may well have been met. We say that it is not the function of the court at the strikeout stage to make such a determination either way. But it certainly is wrong to strike out a case on the hypothesis that the defendant's case may well be correct in fact. Second, we say that prima facie, based on the evidence we have seen, which is limited because we have not had disclosure, the documents suggest that the target was hard-edged in nature. Targets are, of course, set for a purpose, that they will generally influence the behavior of employees. Targets may cause greater efforts to be exerted to reach a target. It may also reduce efforts above the target. And indeed, if you exceed the target in sales or procurement, you make a rod for your own back for the next year. Now, it may sound rather quaint, but this year's Brick Court Chambers centenary, we had a target to raise £250,000 for various legal charities, and we just about last week met that target. And I I can assure the bench, the court, that we have no bandwidth to exceed the target as things stand. So it's a simple point that if one has a target, one will try one's utmost to reach it, but it is within human nature and behaviour to hit the target and not more. Third, we say that FCA sought overall costs certainty to plan its annual production of cars. Once it hit the target, it then needed to factor in the effect on its supply relationships, which were vital to FCA, of punishing suppliers so much that they were no longer keen on tendering for FCA's business. Fourth, we say that the same consideration in relation to exceeding the targets must apply in Sainsbury's. And in the CAT judgment in Sainsbury's, I don't think this page is in the bundle, but I'll give you the reference. The CAT found in 4611 that Sainsbury's would have reduced its costs as much as possible. And yet, in the appeal in that case, the Supreme Court still found that cost reduction could, in principle, be a form of mitigation, notwithstanding, in full knowledge of the fact, that there was a finding that Sainsbury's would have tried to do this in any event. And incidentally, what that reference to the CAT judgment in Sainsbury's in my submission shows very clearly is that these questions of causation and were the targets hard-edged are quintessentially matters for trial.
So what was the paragraph number of the CAT judgment in Sainsbury's?
It's 4611. Well, I'm afraid it's not in the bundle. We can obviously make it.
Don't worry, don't worry.
And finally, we say that, at least in the first instance as a matter of pleading, it is sufficient for my purposes that we have pleaded these targets. If in the factual scenario the loss was in fact mitigated, we say based on paragraph 216 of Sainsbury's, the burden then shifts to FCA as an evidential matter to show that in the counterfactual they would have stopped. And there was no evidence from FCA on this, and indeed the only evidence which had been disclosed suggests that the target was hard-edged in nature.
Does it matter if it's hard or soft-edged? Isn't the real question whether the target includes the overcharge? What's the relevance for target if it doesn't include the overcharge?
Well, it would certainly, my lord, include any increase in bearing costs.
But that might be different to the overcharge. Maybe a component of it, but an increase. I mean, you may get increases quite independent of the overcharge. Steel costs go up, and in a competitive market, some of those increases may be quite legitimately and competitively passed on.
Or they may not be.
Or may not be.
Yes.
But the target, you've got to go from the existence of a target, which we see, to the fact that it would negate the overcharge. And that's the leap in logic which you've got to get over.
At least sufficiently arguably
Yes.
eliminate the overcharge.
Well, the overcharge claimed is 100 million euros. The percentage of overcharge increase is something in the order of 21 to 22%. We say that even for a business of FCA's size, the suggestion that is some sort of loose change or some de minimis cost increase that they would fail to notice.
But I thought that the tribunal, did the CAT not find that it was a relatively minor,
It's a very small.
Yes.
very small proportion of their overall costs?
Yes.
So, I mean, points like, well, they couldn't possibly have missed it or whatever. And there's just no evidential basis for that whatsoever.
Well, in Sainsbury's, the interchange fee was a fraction of 1%.
And every transaction.
Yes.
In every transaction, and it was known. Now, you're right, of course, it wasn't always regarded as anti-competitive, but it was always known about. It was out there, so they knew that they were incurring that loss.
Well, what one sees in my submission, both from the evidence I've shown you from FCA and from the level of granularity we see in Mr. Linati's statement on forcing suppliers to pull up their petticoats in terms of understanding on a very, very detailed level individual cost components, hiring external consultants to effectively audit those costs. FCA was a company who was sophisticated and obsessional about costs and targets, We say that whether one looks at this overcharge in absolute terms or in percentage terms, whether it's 100 million or 20%, this is something which in all likelihood they would have perceived or would have led to reactive measures on their part in the form of putting pressure on other suppliers to mitigate.
You've just inserted the fact you've done. In all likelihood, they would have perceived. I mean, you've got to remember there was a commission decision which said this was a classic response to competitive tendering, namely the cartellists got together, they exchanged sensitive information about RFQs, they coordinated their responses, they agreed who was going to bid, and they made sure they didn't undercut each other. In a sense, even if there was countervailing buyer power, there was a strategically devised system to negate it. So, and to prevent them from doing the very thing you say was.
Well, the essence of which was a completely opaque approach.
Well, that's why.
So Fiat could ask as much as they like, but they weren't going to get information which would have told them that they were being overcharged. That's the point.
Well, there are 3 points of response. First of all, we say again that is a question for trial. Second, the long antecedents of these supply relationships is important because there was a substantial pre-cartel period, probably many decades, in which they had detailed insight into the costs and competitiveness of these suppliers. The third point, again, will be a matter of trial, but there is substantial evidence that many of these parts were carryover parts where the prices were negotiated pre-cartel, even if the physical supply occurred during the cartel. So there were certainly benchmarks pre-cartel. Of course, there were other suppliers who were not in the cartel, and there will be evidence on that. So we say there were a range of indicators or measures or benchmarks which would in practice have been available to FCA, who again was obsessional about cost controls, that would have allowed them to perceive a change in the level of bearing pricing, and then directly to take reactive measures with other input suppliers to deal with those cost increases. And we say, in a sense, the reactive mechanism in this case is much more straightforward than in Sainsbury's. Again, in Sainsbury's, they had literally thousands and thousands of retail products being supplied. In this case, there is a tangible limit into the number of component suppliers you have for a particular vehicle. And it is a much more tractable level of cost scrutiny in this case. And we see from their own evidence, Mr. Lunati's evidence, that they were unbelievably sophisticated in dealing with input costs in particular. And when one thinks about this, so what Mr. Lunati says is they would come to us and demand an extraordinary level of detail into how the cost of the bearing was made up. And if one thinks about this in terms of legal practice, I mean, imagine if a client comes to you and says, Mr. Donoghue, I see your hourly rate. Can you tell me how much Brick Court pays for electricity, for water? What is the rent in your room? How much do you pay for travel? And so on. I mean, this is an extraordinary level of control over suppliers. It really is something exceptional. And the automotive OEMs are the complete masters of buyer power and procurement. So we are saying in trial, and we will be saying in trial, that the level of control of costs and the level of buyer power was something extraordinary in this case. And that is why we say it is a misnomer to say that our defence is ordinary budgetary controls. We're actually concerned with pretty exceptional, or at least onerous, particular measures in relation to cost control of the kind we've just seen. So we say if there is one business...
Is it your pleaded case that they knew they were being overcharged?
No. Our case is that they would have perceived an increase in the cost of bearings, and they would directly have reacted to that through one of two forms of mitigation, perhaps in parallel.
I suppose there's 3 forms of mitigation: pass on, negotiate your suppliers' cost down, or compensate from third parties, which is what we're dealing with now.
Well, that is why we say the idea that a different set of principles would apply as between the different forms of mitigation is illogical. Because the effect of engendering a set of principles that are detached from the compensatory principle may well be to deny a valid claim by another customer, a third party, or to give compensation to someone who in fact has not suffered any loss, and to cause double or treble recovery of damages, which is the one thing everyone agrees English law does not do. So that is why we say there has to be a unity of principle between the different forms of mitigation. We say that that is what one gets from Sainsbury's. That is why I have said more than once that the question of subjective knowledge, the mechanism of ordinary versus some other form of mechanism for recovery, is a red herring, because in the context of pass-on mitigation, these questions would simply never be asked. All one is interested in is how has the firm reacted to a cost increase? Has it increased prices to its customers, or has it sought to reduce other input costs from other suppliers? What the CAT has done is introduce a unique set of principles in relation to the second form of mitigation. We say there's no basis in principle for that. What it does in practice is virtually guarantee that in most of these cases, a mitigation defence that in principle, the Supreme Court says, is available, will in practice never be available in these kinds of cases. And for this to be done in the context of strikeout, we say is something extraordinary. One final point before I sit down. This straddles grounds 3 and 4. I mean, it is in my submission worth recalling. I mean, these issues are very interesting, and if this goes to trial, they will be difficult and interesting issues. But we are in the realms of strikeout, and it's important not to lose sight of that. I mean, sometimes I find that principles I think I'm very familiar with, it's often good to remind oneself what they actually say. We can quickly go to the easy air judgment. I mean, look, Lord Bingham at one stage said strikeout was for clear and obvious cases, something which is unarguable, almost incontestably bad. So in the vernacular, it's for the hopeless case. And Mr. Justice Lewison's formulation, easy air, which is in Authorities Bundle 6, I think has become the most frequently cited statement on the question of strikeout and summary judgment.
Yeah.
So it's on page 63. So, little Roman 3, the court must not conduct a criminal trial. We say in effect, that's what the CAT has done here. It is assumed that a trial we would be unable to make good our point, our case. This was the hard-edged target. Little 4, the end, particularly if contradicted by contemporaneous documents. We've had virtually no contemporaneous documents on the mitigation defence. The handful of documents we have been given, including Ms. Whiteford's evidence, we say all point in one direction, and they are contemporaneous. Little 5, the evidence that can reasonably be expected to be available at trial. Again, we say no regard has been had to that. Then little 6, towards the end, a similar point. Reasonable grounds exist for believing that a fuller investigation into the facts of the case would add to or alter the evidence available at trial, to the trial judge, and so affect the outcome of the case. And then 7, give rise to a short point of law construction, and if the court is satisfied that it has before it all the evidence necessary, and again towards the end, such material is likely to exist, can be expected to be available at trial. And then I'd ask you to note at 16, Mr. Justice Lewison says, on the factual assumptions, I have made in open air's favour. So at that stage, for purposes of strikeout, he was content, and we say obliged to, assume that what was put forward was something that could be assumed to be correct for purposes of the pleading. And in this case, we say the CAT has done the opposite.
The CAT in this case applied the summation of this case in Royal Mail. There doesn't appear to have been a dispute as to the correctness of the CAT's reformulation in Royal Mail. Do you accept that that was a reasonable summation of the principles?
Oh, yes. I mean, my criticism is not so much that they didn't recite by essentially cross-reference. principled was that they ignored them when it comes to applying them in this case. One final point, if I may. Your Lordship mentions Royal Mail, which is entirely correct. Now, we say two things. One, it really is quite extraordinary, as I said, that in the context of an amendment which was triggered by the Supreme Court in Sainsbury's, that there was no reference in the CAT judgment in our case to anything I have shown you in interchange. We say that is nothing short of extraordinary. Because particularly on the question of ordinary budgeting, paragraphs 215 and 225 make explicitly clear that ordinary budgeting is in principle capable of being a proximate cause, certainly for legal purposes.
Yeah.
Now, I mean, your Lordship's ladyship's hand. I mean, I can explain to the court why we say the Royal Mail judgment can be distinguished, but it may not matter for present purposes.
You're going to take us to the pleading itself, particularly the voluntary further better particulars.
Voluntary particulars.
Yes.
Tab 8, aren't they?
Well, it starts at 63. We say to rely at this stage on the following particulars: A, control of costs; B, targets; little 1, targets for total cost; little 2, targets for reductions of costs. Targets were set prospectively. They were a benchmark, so that's the hard edge point. And there was measurement. FCA measured the performance of FCA's procurement staff in meeting those targets and provided incentives accordingly. And then at C, the particular tools for monitoring, which we saw in paragraph 59 of this point for its statement. And 4 is again the hard edge point. Ensure that the total input cost for a vehicle or part of a vehicle did not exceed a specific level. 5, we infer that they were an effective means of controlling costs, also useful in planning overall budgeting, ensuring they made a profit. So they would set cost targets and seek to ensure that these targets were met, so they could plan the levels at which they price their products. If effective, a cost target would mean that FCA procurement staff will negotiate the price of basic inputs so that the total costs of the inputs did not exceed the target. So again, the benchmark or hard-edged point. Again, FCA, last part, FCA's procurement staff would look to reduce other input costs so that the overall target was met. 8, we say we need further disclosure. 9, we make the point at paragraph 216 in Sainsbury's about the heavy evidential burden on FCA, us having raised this plea to deal with how they treat costs within the business, and of course a statement of truth at the conclusion of particulars. So we say in the circumstances, in the absence of any disclosure, apart from a tiny handful of documents inadvertently disclosed, we say these particulars are the best we can do and are more than adequate at the pleading stage to raise a case that can go to trial, and in which context there will be a shifting evidential burden.
So you've got evidence, if you like, particulars for what is said in paragraph 3, possibly 4.
Yes.
Thereafter, you're drawing inferences from the mere existence of a cost control scheme with targets, but you then get to the conclusion, which is conditional upon the if effective in paragraph 6, but you get to the conclusion in 7 that FCA would have negotiated lower prices and offset an overcharge. I mean, that's the leap. How do you get from a mere existence to a target, which may or may not be successful even with the most effective system in the world, to a negation of the overcharge? You've got inferences. Inferences are conclusions drawn rationally from known facts. So let's assume that 3 and 4 are properly particularised facts which we can assume are truth and correct, investing the proposition, that everything that follows has got to be logical. And you've got an inference, you've got a series of inferences in 5, you've got more inferences in 6 which build on those in 5, and then you've got 7 in the premises, so that's another inference. If there was an overcharge, which there wasn't,
Would have been.
would have,
Constant
absolutely.
use of the words would have been.
Yeah.
All of which are words of inference.
Yes.
Not of what in fact happened, but of what you infer
And it's not might.
might have happened.
Well, there is an element of conditionality, because of course we're referring also to the counterfactual. So it's both the factual and the counterfactual. But well, I'll make 2 points if I may. First of all, one has to bear in mind that apart from Ms. Whiteford's statement and literally a handful of documents, we have received nothing by way of disclosure on this point. Now, the documents and evidence I've shown you, we say prima facie, show these targets were serious, hard-edged, it is common ground they existed and they were acted upon. And we say it is more than reasonable to infer that they were there for a reason. And it would have been the easiest thing in the world for FCA to put in a very short statement saying, well, you say these are hard-edged, but here is the head of procurement who says they're not, that they were frequently exceeded, or something along those lines. And we've had absolutely nothing. And instead what the CAT has done is, in the absence of any evidence in the other direction, essentially treat this pleading like a statute. So we say, bearing in mind the asymmetry of information, the lack of disclosure, the limited disclosure we had, which we say is extremely revealing, there is a more than reasonable basis for the inferences that we need to make. And our case is that these targets were real, were effective, and were hard-edged. So that in a counterfactual world,
Even assuming all of those to be true, does it necessarily you get to the overcharge would have been negated? I mean, I know you say catch-22, to which Ms. Ford is going to say, well, fishing. You know, this is, what is the threshold that you have to get over in order to get the disclosure? You can't simply say, can we have disclosure to see if it makes good our case? You've got to be able to establish that threshold. You've got to have something to get into.
well, this pleading arose directly out of the very limited disclosure we had, because the sequence again was that we had no disclosure mitigation. When we made our disclosure application, we sought disclosure on the targets. We received nothing apart from essentially inadvertently a witness statement and a small handful of documents. And what they showed were hard-edged targets per vehicle, minute percentages of changes in cost being tracked throughout the organisation. And if one aggregates that up with what we see in Mr. Linati, for example, this sort of obsession with cost control and granularity, we say that there is more than an adequate basis as a matter of pleading for what is set out and to the extent necessary any inferences. And one final point before we sit down. In Royal Mail, of course, one of the amendments on mitigation was allowed to proceed to trial. And the other amendment which was struck out, what the CAT said was, well, DAF has told us that they don't think they need any more disclosure to make good this point. But there is a scenario in which they will get some additional disclosure on cost generally. If, having received that disclosure, they want to come back and replead the part that we have struck out, in principle we would not be opposed to that. So even in relation to a completely hopeless amendment, where all they had was an economic theory, the CAT, the president in that case, said, well, you can come back and have another go. In our case, where our pleading does not rely on economic theory, where we have some factual basis based on FCA's uncontested evidence for setting out what we set out, the CAT has shut us out completely, and it cannot advance now to trial. We say that is fundamentally
That happened in
unjust.
Royal Mail because it was an arguable mitigation defence which was allowed to go forward. If there hadn't been, then none of that would have applied.
Yes, but well,
The
that's right.
defendants in Royal Mail would have been in exactly the same position as your client.
Although I'm focusing on the amendment which was struck out. Your Lordship is right, one of the amendments was let in. But on the amendment which was struck out, the CAT said, well, you may in due course get disclosure on.
Only because they were going to get disclosure on the one that was allowed in. If none of it had been allowed, then that would have been the end of it.
Oh no, it was pass on.
So I'm not sure how that helps you with respect.
Well, it was pass on disclosure. It wasn't in relation to the.
Yeah, but nonetheless, the point that the CAT were making in Royal Mail was it may be that from the disclosure which you're entitled to and you will get, you'll be able to plead something. I don't think anything has been, at least not yet anyway.
Yes, well, we had no disclosure. We will get no disclosure, as matters stand.
Okay.
So we say there's been a double standard. They've been allowed to have a second go based on disclosure. We've been shut out indefinitely. And well, this is a very important defence for the company. The company, as matters stand, is not profit-making. This is an enormous claim. It has significant implications for the company. And this is one of a small handful of defences that we wish to run a trial. I mean, the costs of this litigation are eye-watering. FCA is forecasting, I think, legal costs of something of the order of £8 million. This is a €100 million claim. To suggest in that context that we cannot even begin to run an important defence, a trial, we say is fundamentally unjust.
Is the €100 million or is it dollars or sterling?
It's euros, my lord. It includes, of course, interest. But they're claiming an exorbitant overcharge of 21%, €100 million including interest. We can't even begin to run all the three defences that we wish to advance. So, my lord, we say that errors of principle have been made in relation to all grounds, and that what we have pleaded in the circumstances, given the constraints, given the asymmetry, is more than good enough to go to trial. So, my lords, my ladies, those are my submissions.
Thank you very much, Mr. Any questions? No. Thank you. Yes, Ms. Ford.
My lords, my lady, I'm proposing to structure my submissions under 4 heads. First of all, the applicable legal principles, then the defendant's pleaded case, thirdly, the tribunal's judgment, and then fourthly, and hopefully briefly in the light of what's gone before, I will make submissions on the 4 grounds of appeal. In summary, my submission will be that the tribunal was not purporting to formulate or apply any new or novel legal principles in this case. It simply applied the straightforward requirement for a causal link between an overcharge and reductions in costs that dates back to British Westinghouse and beyond. And it rightly concluded that the defendant's pleaded case had no real prospect of success because the cost reduction process was independent of and did not arise out of the overcharge. So starting with the legal principles, Mr. O'Donoghue starts with Supreme Court at Sainsbury's, but we say the trail starts earlier with British Westinghouse. It's in tab 2 of the authorities bundle. And this is a case that was concerned with a contract for the supply of turbines, and the turbines were defective and non-compliant with the contract. And so the respondents purchased substitute turbines, which are referred to in the judgment as Parsons machines. And the Parsons machines were more efficient than the appellants' turbines, even if they had complied with the terms of the contract. And that gave rise to a situation where not only had the purchase of the machines mitigated any loss for the future, but they'd actually put the respondents in a better position than they would have been had the contract been complied with, because they were so superior in terms of their efficiency. And so the question arose, could you take that fact that they were in a better position into account for the purposes of calculating damages? The Divisional Court and the Court of Appeal both said that you did not take that fact into account, and the House of Lords disagreed. Starting at page 689. Sorry, it's the internal page 20.
Yeah.
These are the principles that Mr. O'Donoghue has already taken you to. And he starts at the top saying, I think there are certain broad principles which are quite well settled. The first is that as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed as far as money can do it in as good a situation as if the contract had been performed. That that's obviously the familiar compensatory principle, albeit in the context of a contract case rather than a tort case. And then he then says this first principle is qualified by a second, which imposes on the plaintiff the duty of taking all reasonable steps to mitigate the loss consequent on the breach, and debars him from claiming any part of the damage which is due to his neglect to take such steps. And he goes on, the part that's sidelined, as Lord Justice James indicates, this second principle does not impose on the plaintiff an obligation to take any step which a reasonable and prudent man would not ordinarily take in the course of his business. But when in the course of his business he has taken action arising out of the transaction, which action has diminished his loss, the effect in actual diminution of the loss he has suffered may be taken into account even though there was no duty on him to act. And we place emphasis, as did the Supreme Court in Sainsbury's, on the words arising out of the transaction, because in our submission that sets out the very clear requirement that you have to have a causal relationship between the breach on the one hand and the benefit that's going to be taken into account on the other. Viscount Haldane then proceeds to give various examples or various authorities which illustrate the rule he's identified. And I simply draw the court's attention to the fact that the authorities, the initial one then dates back to 1878, and then over the page you have authorities dating from 1911.
It's actually earlier than that. Stanford and Lyle. Tim Bingham's reports. It's I don't know the precise date, but I imagine it's about 1800.
Your Lordship might well be right that it goes back even further. The simple point we make is that
an older case.
these propositions are not new. And
That's a classic example, isn't it, where as a consequence of the breach, you do something else, and as a result of which what you do turns out to be more profitable than the contract would have been.
Oh, Lord, yes. And there's another example in there where there was a breach of a shipping contract, and as a consequence the captain undertook a circuitous route home, and actually that second voyage then turned out to be more profitable, and that's another circumstance where Viscount Haldane says you do take that into account. And he reiterates the relevant principle on page 21 after his recent illustrations, and he says this is the middle of the page, the sidelined passage. The subsequent transaction, if to be taken into account, must be one arising out of the consequences of the breach and in the ordinary course of business. And what he then goes on to do is to give 3 examples of cases where you don't take a benefit into account because there is no causal relationship. And the first one he cites is Bradburn and Great Western Railway, and that's an example of an insurance policy, and that's not to be taken into account in the reduction of damages.
It's collateral benefits, isn't it?
My Lord, yes, it is. And the wording he uses to express that, this is on page 21.
Yep. Contract
says-
wholly independent of the relation between the plaintiff and the defendant.
Your Lordship has it, yes, wholly independent of the relation. And similarly, he then cites the Jebson case, which was a delay in discharging a ship from dock, and as a consequence, passengers were lost that were supposed to be taking passage on the ship. And the passengers took a ship on another vessel which belonged to the same plaintiffs. And the court said, you don't take that into account either. And the reason for that, on page 22, right at the top, they say what was relied on as mitigation did not arise out of the transactions, the subject matter of the contract. So again, no causal relationship between the breach and the benefit. And then the final example they give is a lessee of a premises who delivers them up in poor repair, and it's held that the landlord is entitled to recover the costs of putting the premises back into repair, even though the landlord had a new lessee. The new lessee actually did the work and didn't ask to be reimbursed for the cost of the work. And the reason why that isn't taken into account is in the sentence beginning moreover, about halfway down the page. It says, moreover, the arrangement between the lessor and the new lessee was res inter actus alia, with which the original lessee had nothing to do and which he is not entitled to set up.
No.
So again, essentially completely unrelated, no causal relationship. And having cited those examples, you then see Viscount Haldane at the bottom of 22 saying, I think the principle which applies here is that which makes it right for the jury or arbitrator to look at what actually happened and to balance loss and gain. The transaction was not res inter alios acta, but one in which the person whose contract was broken took a reasonable and prudent course, quite naturally arising out of the circumstances in which he was placed by the breach. So again, language of causation, and over the page on 23, he comments that the fact of purchasing the Parsons machines formed part of a continuous dealing with the situation in which they found themselves and was not an independent or disconnected transaction. So in our submission, the test that comes out of British Westinghouse as to whether or not you take into account a countervailing benefit in calculating damages is whether the benefit actually arose out of the consequences of the breach or whether it was an independent and disconnected transaction. Mr. O'Donoghue has also cited Platt and London Underground, which is in the following tab in the bundle. And in our submission, Platt is entirely consistent with the principles you see in Westinghouse. He took you...
Well, the only reason why they were able to make more money at the second kiosk is because of the breach in relation to the first one.
My lord, that's absolutely right. But this is a case in which the court was actually taken to these various principles about independent transactions. So if we look at the passage Mr. O'Donoghue cited is at L on page 29. And at M you can see attention being drawn to the passage in Chitty which says advantages gained by the claimant from wholly independent transactions, especially those entered into before the defendant's breach of contract, as for example a sum due under an insurance policy, cannot be relied on. So these principles and points were made to Mr. Justice Neuberger as he then was. And the way he dealt with them is over the page 30 next to E, where he points out the contracts under which the claimants respectively lost and gained were entered into on the same day between the same parties and were part of the same overall transaction, namely relocating the claimant's business from 75 Tottenham Court Road as a result of the compulsory purchase order. So what he's saying there, in my submission, is entirely consistent with British Westinghouse because he's saying actually these are not separate independent circumstances, it's all part of the same transaction. And in that circumstance it makes sense that you assess the damage as it arises in the context of that single transaction. This is not a situation where you've got an independent transaction which is causally unrelated. My lords, those familiar principles are then applied by the Supreme Court in Sainsbury's, which is tab 10 in the bundle. And Mr. O'Donoghue showed you at page 267, paragraphs 175 and 176, which is where the Supreme Court is setting out the narrow issue which it was asked to consider. And the court has the point that it's not here specifically considering the requirements for an adequate plea of causation in the context of the pleading stage or what's required for an adequate causal link. It's not actually considering the issue that is before this court. If we turn on to 205, Mr. O'Donoghue also showed you this paragraph. And this is where the Supreme Court is identifying the ways in which retailers might respond to the imposition of cost. It says at H, they can respond to the imposition of a cost in a number of ways. And I do place emphasis on the wording the Supreme Court uses here because it is saying they can respond to the imposition of a cost. In my submission, the reference to a response, or the way in which they respond, is important because the Supreme Court is thinking about this in the circumstances of these cases as already involving a relationship of causation. It's saying that the merchants can take steps in response to the imposition of a cost. And it was canvassed with Mr. O'Donoghue that this is a situation where the parties were aware of the relevant charges. And it may be that that's the reason why the Supreme Court is thinking in terms of a conscious response to a cost of which they're aware. Obviously, one of the ways in which the Supreme Court identifies that a retailer might respond to a cost is point 3, the merchant can seek to reduce its costs by negotiation with its many suppliers. That's over the page. And opposite B on this page, you see again the Supreme Court saying which option or combination of options the merchant will adopt will depend on the markets in which it operates, and its response may be influenced by either the cost, influenced by whether the cost was one to which it alone was subjected or was one which was shared by its competitors. So again, it's being expressed in terms already of a causal relationship between cost and response. You then see at 206, the Supreme Court saying if there's evidence that they have adopted either option 3 or 4 or a combination of both, then the compensatory principle mandates it to be taken into account as a matter of mitigation, and they turn to consider the principles in mitigation. And in that context, the Supreme Court...
dealing with a threshold issue at all.
My Lord, they're absolutely not. They're not turning their mind to the issue that's before this court at all. Paragraph 215, you do see them referring specifically to British Westinghouse, page 275. 215 on page 275. Once again, you see a reference to benefits resulting from a victim's response to a wrong. So again, the way in which the Supreme Court is considering it here already assumes a relationship of causation. And over the page, you see they cite from British Westinghouse, and they emphasise at B the passage that we saw when in the course of his business the claimant has taken action arising out of the transaction, and they italicise the words arising out of the transaction. And they say here also a question of legal or proximate causation arises, as the underlined words show. So in my submission, it's very clear that the Supreme Court is not intending to depart from the well-established principles in British Westinghouse. It's citing them and it's emphasising the need for a causal relationship. And it then goes on to express a view, really in passing, that the question of legal causation is straightforward in the context of a retail business in which the merchant seeks to recover its costs in its annual or other regular budgeting. And as the court will appreciate, a lot of emphasis is placed on this by Mr. O'Donoghue. In my submission, it's clearly not intending to water down the causal relationship that's required in British Westinghouse. And the way it's expressed here is understandable, given that we've seen the Supreme Court is proceeding on the basis that these are steps which are taken in response to a cost. So it's proceeding on the basis that there is already a requirement of causation which is satisfied. And in my submission, that's why it thinks that legal causation will be straightforward in the particular circumstances of this case.
Well, you talk also, don't they, in that last sentence of 215 about a merchant, by reducing the cost of supplies, transferring all or part of the loss. So it's talking about transfer of the loss, to be contrasted with a situation where the merchant reduces its costs as a matter of course, which has got nothing whatsoever to do with the loss that it suffered.
My Lord, yes, it is not contemplating a situation where it reduces its loss as a matter of course, because it's already thinking about this in terms of a conscious response to a loss. You then see at 216 the Supreme Court saying that although the legal burden lay on the card schemes to establish that the merchants have recovered their costs by way of pass-on, including cost mitigation, once the defendants and the proposed appellants have properly raised the issue of mitigation in their pleading, there's a heavy evidential burden. And that is important because, as we'll see, the tribunal emphasises in Royal Mail that it would be inappropriate to impose that sort of heavy evidential burden on a claimant absent a proper pleaded basis to do so. So turning to what the tribunal said in Royal Mail, it's tab 13. starts with paragraph 20 on page 317. This is another case where the Supreme Court's judgment in Sainsbury's has inspired the defendants to plead a costs mitigation argument. And you can see what they pleaded at paragraph 20, the paragraph 30C. Further on, the alternative, DAF contends that the claimant mitigated any overcharge by reducing the costs which it paid to its suppliers. Without limitation, DAF avers that the claimant will have sought to mitigate any increase in its input costs by virtue of any such overcharge by negotiating lower input costs and or otherwise reducing its cost of supply. That was the pleaded case that was before the tribunal in Royal Mail. 22, the tribunal sets out the relevant legal test for allowing an amendment, and the court was already canvassed with Mr. O'Donoghue. There's no real issue taken that this is the appropriate legal test. There has to be a realistic prospect of the plea succeeding at trial, and a realistic chance is one that carries some degree of conviction and is more than merely arguable. Paragraph 24, you can see that in this case it was common ground that there must be a sufficient causal connection as a matter of law between the putative overcharge and the way in which the loss was mitigated. That's accepted by DAF in that case. 25 and 26, the tribunal is citing the relevant passages from the Supreme Court in Sainsbury's. 27, the tribunal sets out the claimant's objections to permission to amend in that case. And 28, it sets out what was the response. And it records DAF's response to the claimant's objections is essentially that Sainsbury's and Visa Europe gives it the green light to plead paragraph 30C, and that what is required by way of causative connection is a subtle and imprecise question that can only be determined on the known facts of the case and must therefore be determined at trial, not at this stage. As the court will appreciate, there's a certain symmetry between the arguments that are being advanced by Mr. O'Donoghue before this court and what was said by DAF before the tribunal here. Paragraph 29, the tribunal highlights that there would be serious implications of this sort of argument. It says, if the observations of the Supreme Court are the consequences which DAF suggests, they would appear to us to have serious implications for claims of this kind, where a trader who supplies goods or services alleges an overcharge by a cartelist supplier, apart from any assertion that the trader in fact passed on to its customers the burden of the overcharge which it incurred. The cartelist would be able simply to allege that the trader has reduced its other costs in response to the overcharge, so that its overall amount of input costs remains the same, or at least increased by less than the amount of the overcharge, thereby negating or reducing the impact of the overcharge and its recoverable damages. In paragraphs 31 to 33, the tribunal was elaborating on the concerns that it consider arises if this is going to be permitted. It's pointing out that if a defendant were able to plead in general terms that an overcharge was mitigated by measures taken to reduce costs from other suppliers, it would throw a significant evidential burden onto a claimant to demonstrate how it conducted its business in financial terms to minimise its costs on a year-by-year basis. The defendant will not be able to give particulars of how the claimant mitigated its loss, save to allege that it would have done so in response to the overcharge. Only documents disclosed by the claimant will show what was done following the overcharge, by whom, at what levels in the claimant's business, for what reason, with what consequences for its budget and cost control processes, and with what results in terms of its supply costs in following years. It goes on to make the point that it's not only in EU competition claims that this issue is going to arise. It's going to be an issue, says the tribunal, for many commercial claims for damages by businesses, where what is alleged is that financial loss was caused by a breach of contract that left the claimant continue to run its business with its cash balance or income adversely affected. So it's saying that this has serious implications across the board, not just for competition law claims.
Well, that example at the end of 32 picks up some, at least in a sense, isn't it? One of the examples of the cases that Viscount Haldane cites, which is the example of the contract with the third party. And that's a classic example. If what you do is you have other contracts and you reduce the costs you incur occur in making other contracts. That in itself is res inter alia acta, unless there is some causal link between that decision to reduce your costs and this particular breach of contract.
My lord, yes, and the
So
tribunal.
if in response to the overcharge you do something, that's one thing. But if all you're doing is carrying on your business the normal way and trying to, as it were, reduce all your costs, screw your suppliers to the floor, then so what? That's what business people do.
My lord, yes, and Viscount Haldane says, why should the defendant, who has committed a legal wrong, be able to point to things with which it's got no involvement, which have no relationship to the defendant, and say, aha, well, you're no worse off. 33, the tribunal was referring to the passage that I showed the court in Sainsbury's about the evidential burden which is cast on the claimant. And at the end of 33, they say there's a real risk in our view of infringement of this principle unless there is some basis other than pure theory for believing that a defence of mitigation has some factual basis for it and so can be properly pleaded.
This is the principle of effectiveness.
I'm sorry, my lord, yes, it is.
Yes. I mean, there's quite a lot of principles which are thrown around: effectiveness, proportionality, equivalence, broad acts, approximation. They all really amount to the same thing, which is that if you've got a right, the court should not impose procedural or evidential rules which make the enforcement of that right very difficult.
My lord, that's right, yes.
Respecting, of course, rights of defence, but they all really, it's not as if it's a European principle. The common law reflects very much the same thing.
My lord, that's absolutely right. And what's being said here is that in the light of what the Supreme Court has said, that if by raising, obviously the word raising was used in the judgment, if by raising this defence you are immediately imposing upon the claimant an evidential burden, that does raise concerns under EU law, under common law, about the consequences for pursuing a cartel claim and broader claims. So there are policy concerns with imposing a too low threshold for raising this sort of defence. And for that reason, they expressed the view at 34. For all these reasons, we do not consider that the Supreme Court could have been intending to countenance or encourage such an approach to pleading a defence of mitigation. And they go on to make some of the points that I've made in submission to the court, that this wasn't argued before the court. They were dealing with a broad acts principle. It refers to the principle of equivalence, the fact that the Supreme Court had that in mind. Say at the end, a claimant such as Royal Mail or BT in a damages claim under competition law should not be more vulnerable than a claimant in a domestic commercial claim to a defence of mitigation. And so we come to paragraphs 35 and 36, and this is where, in my submission, the tribunal is setting out a statement of principle as to what is required by way of a proper pleaded case. And in my submission, the statement of principle that it sets out isn't a controversial one, because what it's saying is you need to identify a causal link. So they say, it seems to us that it cannot be enough for a defendant to plead that a claimant's business input costs as a whole were not increased, or that as part of the claimant's business, ordinary financial operations and budgetary control processes, its overall expenses were balanced against sales so that profits were not produced. There must be something more to create a proximate causative link between the overcharge and a reduction in other input costs so as to constitute mitigation. And they cite from the British Westinghouse case. Paragraph 36, we therefore consider that for a defendant to be permitted to raise a plea of mitigation in this way in general terms, there must be something more than broad economic or business theory to support a reasonable inference that the claimant would in the particular case have sought to mitigate its loss, and that the steps taken by it were triggered by, or at least causally connected to, the overcharge in the direct manner required by the British Westinghouse principle. In my submission, that statement of principle is not a controversial one. It follows from what is said in British Westinghouse. Turning on to paragraph 42, the tribunal comes back to make similar observations, but in this paragraph what it does is it offers some examples of circumstances where it thinks actually you might be able to demonstrate the relevant causal link. So it says, before a purely general plea of mitigation through business cost reduction processes can be pleaded, in the way that DAFs seek permission to do, there must be something identifiable in the facts of the particular case that gives rise to a prima facie inference that there may well be a direct causative link between the overcharge alleged and the prices paid by the claimant for other supplies that reduce the amount of the loss resulting from the overcharge. What is sufficient to give rise to such an inference will vary from case to case, but it may be found in facts such as a claimant's knowledge of the nature and amount of the overcharge, such that it is inherently likely that the claimant would seek to address it, the gross amount of the overcharge as a proportion of the claimant's relevant expenditure. The higher the proportion, the more likely it is that some step would have been taken to mitigate the impact. The relative ease with which the claimant's business could be expected to reduce certain input costs or input costs generally, or the fact that other supplies made by the defendant or its associates to the claimant have been renegotiated in years following the increase in the prices alleged to have been caused by the anti-competitive conduct. So it's giving concrete examples, and we'll come on to see that the tribunal in this case did work through those possible examples and consider whether there was any basis to suggest that they applied in this case.
Can you just explain how the fourth example works? I can understand the first three. Is this about comparators?
My lord, I think it's simply an indication that if you do go and readdress your input costs from the defendant, that would suggest causally that you're looking to reduce your costs in some way in response.
Yeah, I mean, it's just saying, isn't it, that this is not dealing with your supplies from third parties. It's dealing with your supplies from the defendant itself.
The fourth
Somehow,
point is, yes,
as it were, since the anti-competitive conduct, you've actually got a reduction from the defendant you wouldn't otherwise have got, and that can be taken into account.
my lord, that could, because obviously there's a very clear causal relationship between actually renegotiating your relationship with the same defendant in response
Perhaps it
to
doesn't necessarily tell you anything about your ability to negotiate away the overcharge, which is a percentage of the percentage, if you like. It's not the actual. I mean, I suppose it just may be one piece of evidence which might be relevant.
My lord, I think that must be right. I think it must be.
And of course, depending on how the evidence came out in any case, the claimant might be able to argue that, in fact, the defendant would always give them those concessions in any event.
They might face that up.
I mean, it might be
Indeed,
a
my
bit
lord.
problematic.
And then it would call into question whether it demonstrates the requisite causal link. But it's at least a beginning of a step in the chain if you can point to an active exercise of reduction in costs. In that way, of course, one of the criticisms that we make of the way in which it's pleaded in this case is that there is no concrete plea of any actual reduction in costs at all. The tribunal's conclusion as to the approach in principle is then set out in 43. And they say, we therefore hold that it's not sufficient for a defendant in the position of DAF to plead a defence of mitigation on the basis of broad economic theory and nothing more, where the effect of that would be to place a heavy onus on a claimant to disclose and explain its financial procedures and operations during the period of the operation of the cartel, or if shorter, the period during when the cartel is alleged to have been mitigated. There must be some plausible basis in fact for alleging that the claimant would reduce the amount of the overcharge loss in a manner which amounts to a legal mitigation. That is not to suggest that a defendant must have documents or evidence at the pleading stage capable of proving what the claimant did in response to the overcharge or that it was effective. It is understood that this material is unlikely by its nature to be available in sufficient detail. What is needed is some plausible factual foundation for the application of the broad economic theory in the way required to satisfy the British Westinghouse test that is relied upon, for there being a causative connection between overcharge and cost cutting. So that, in my submission, is the paragraph which really encapsulates the principle. I'm turning to address the defendant's pleaded case, and it's in the core bundle starting at tab 7.
Just before you, paragraph 44 perhaps reflects the difference in facts between Sainsbury's and the present case.
Sorry, I'll open it back up again.
Page 328. Reference there to a transparent service charge. Which of course the myth was. I mean, as Mr. O'Donoghue points out, in those cases the illegal element was the percentage of the myth, not the myth per se.
My My lord, yes, and it may well be that this,
Always, as they say, a transparent service charge to be contrasted with the overcharge, which was not only covert but a tiny fraction of the claimant's expenditure.
my lord,
And you say
absolutely.
that's the same position here.
We're faced with exactly the scenario where you didn't know that there was an overcharge and it is a tiny fraction of expenditure, and we'll see that the tribunal's findings of fact to that effect in this case. But that does explain why you might see an apparent difference of approach by the Supreme Court in Sainsbury's.
You're going to take us to the pleading.
My lord, yes, it's starting core bundle, tab 7, page 60. Relevant paragraph is subparagraph C on this page, where you see the plea in the alternative. If any overcharge was caused, NTN avers that the claimants passed any overcharge through to their own customers or purchasers, or otherwise mitigated their loss, brackets including without limitation through reducing their other costs. And you see a repetition of that formulation further down in the paragraph, or otherwise mitigated, including through reducing their other costs.
I don't think that middle sentence is sustained. I mean, it suggests that there's a burden of proof upon the claimant to prove a negative, Richard.
My lord, yes, and I understand Mr O'Donoghue to have conceded that that's not an entirely accurate recreation of what was said in the Supreme Court. Our submission is that that plea is manifestly inadequate. It advances no basis whatsoever for the allegation, not even economic theory, and certainly not any identifiable facts. And it doesn't plead any causal connection whatsoever between overcharge and cost cutting. So one then turns to the voluntary particulars, which are behind tab 8. Paragraphs 1 and 2 are essentially introductory. What limited factual content there is in these particulars is to be found in paragraphs 3, 4 and 5. And so paragraph 3A pleads that the claimant sought to control the cost of inputs. Paragraph 3B pleads that this was done by means of cost targets. Paragraph 3C explains that the cost targets were set prospectively. Paragraph 3D pleads that the cost targets provided a benchmark for procurement staff. Paragraph 3E pleads that the claimants monitored suppliers' performance. You've then got paragraph 4, which pleads that the purpose of these measures was to ensure that total input costs did not exceed a specific level. And then paragraph 5, which pleads 2 inferences. And the basis of the factual inferences is said to be the fact that FCA used such cost targets. And from the fact that they were used at all, the pleading seeks to infer 2 things. First of all, that the cost targets were an effective means of controlling FCA's costs. And secondly, that they were useful to FCA in planning overall budgeting and ensuring that they made a profit in line with their plans and expectations. That, in my submission, is the full extent of the factual content of the pleas contained in the voluntary particulars. And the reason...
Those are not facts, they're inferences from the primary facts. The primary facts are in paragraphs 1 to 4. I suspect probably we could treat those as reasonable for the purpose of testing the proposition. We're now into an inference. I can see that the second one, that they may be useful, is stronger than the first one, that they were effective in controlling costs.
My lord, yes. I mean, it may be that I was being unduly generous in describing the inferences as factual, but your lordship has the point that they are the sole basis of the inference is the existence of these cost targets. And then what follows in the subsequent paragraphs is not factual in nature at all. It's all hypothetical and, in our submission, speculative.
I suppose if the inference in the first part of 5 that they were effective is reasonable, then it's another, that you then build on that inference. A second line of inferences are those in paragraph 6, but they're conditional, because of course it's if.
Yes, and the only basis of any assumption that it might be effective is to look back at 5 and find that it's their very existence. That's the only.
Which is the existence of the cost target system.
My lord, yes, which is extremely weak in my submission as a basis for an inference. And in our submission, just looking solely at the factual content of the pleading, it extends no further than the fact that the claimants took steps to monitor and control their costs. And that is, in our submission, a completely unremarkable proposition. Importantly, none of the matters pleaded there are matters arising out of any breach or any overcharge, because they allege a cost budgeting process which exists and operates entirely independently of the overcharge, and they would have happened anyway. So we're then moving on to paragraph 6. Your Lordship has already put to me the point that it starts with a hypothetical, if effective, which is itself an inference on an inference. But on the basis of that hypothetical assumption of effectiveness, you then get the plea that FCA's procurement staff would negotiate the prices of the various inputs so that the total cost of those inputs did not exceed the target. Therefore, if one particular input cost could not be reduced through FCA's exercise of buyer power and other sophisticated procurement techniques, FCA's procurement staff would look to reduce other input costs so that the overall target was met. And importantly, there is no positive pleaded case that any element of that theory at all actually ever arose. So if we break it down to its constituent elements, there's no positive case pleaded that there actually were any items of costs which could not be reduced through FCA's exercise of buyer power and other sophisticated procurement techniques. And then there's no positive case pleaded that as a consequence of there being items of costs which could not be reduced, there was an overall target which would not have been met. And there's no positive case that the FCA's procurement staff consequentially looked to reduce other input costs in order to meet that target. And there is no positive case that they were successful in reducing other input costs to meet that target. It is all, in my submission, completely speculative and hypothetical. We do also emphasise that even this hypothetical scenario does rest on unpleaded factual assumptions, and this is a point that's then picked up by the tribunal in its judgment. We say, first of all, it assumes that these pleaded cost targets, which are described as a benchmark, operated as a hard cap rather than some sort of guideline. Because if there was a guideline that could be exceeded, if necessary, then exceeding the guideline wouldn't trigger any conduct to try and cut costs. So it assumes, first of all, that it must be a hard cap. And then it assumes that the claimant's total costs must already have been either at or above the target. Because, of course, if they weren't, then an increase in one cost wouldn't necessarily trigger efforts to reduce other costs. And then it also assumes that when they were negotiating their costs down, the claimants only negotiate their costs down sufficiently to meet their targets. Because if, in the light of all these pleaded performance monitoring and incentives, the claimants routinely negotiated their costs down as low as they could go, then an increase in one cost isn't going to trigger cost reductions in other costs, both because they would happen in any event, and also because there would be no further scope for cost reductions. And finally, it assumes that the claimants would not have responded to a cost increase in other ways. So they could, for example, design their products to a lower specification. They could reduce their discretionary expenditure, such as marketing. And so in our submission, there are many unpleaded factual assumptions in even this hypothetical scenario that's being pleaded. And even leaving that aside, the propositions pleaded in paragraph 6 are, in our submission, inadequate to establish causation because they plead a process of cost reduction which arises entirely independently of the overcharge. It's not a process which is in any way triggered or arising out of the facts of the overcharge. It's something which happens in any event. Turning to paragraph 7, this is where you get the first mention of an overcharge. And the court will see that it's pleaded in the same sort of hypothetical and speculative language that we saw in paragraph 6. And so it pleads that in the premises, if FCA did pay an overcharge on any bearings, the effect of the cost targets would have been that FCA's procurement staff would have negotiated lower prices with other suppliers to offset any overcharge or part thereof. The words "in the premises" indicate that the assertion that's being made in paragraph 7 is based on and goes no further than what has already been advanced in paragraph 6. And so in my submission, it encompasses all the difficulties that I've already laid out as to why this theory doesn't necessarily follow. And you then have this odd hypothetical language, which in my submission is not suitable for a plea in mitigation relating to reduction in other costs. The reason I say that is because this whole issue arises on the assumption that the claimants have actually suffered an overcharge as a consequence of the cartel. In the factual, they have been the victims of an overcharge. And so the premise which underpins it is that there must have been an overcharge. And then what you would expect to see is that in response to that overcharge, there were in fact cost reductions in the factual. This is not, in my submission, contrary to the submission that was made by Mr. O'Donoghue, this is not a counterfactual scenario. The plea that you would expect to see is that there were in fact cost reductions. It's not hypothetical, it's not would. What you're trying to identify is actual cost reductions. And in my submission, it's very telling that there is a complete absence of any straightforward plea that in response to an overcharge on bearings, the claimants in fact responded by negotiating cost reductions in respect of one or more other inputs that they would not otherwise have sought or achieved.
The way in which it pleaded, well, it was that raised in my mind why they hadn't pleaded it as a breach of duty case. If it's going to be entirely hypothetical, why don't you simply say, not that they did, but that they should have? But that then comes up against the problem, which they're trying, I presume, to circumvent, that the court may be reluctant to say that a prudent business has to take steps reasonably to mitigate an invisible cartel.
My lord, indeed, it would be completely beyond the requirement for the steps to be taken only in the ordinary course of business to suggest that you should take steps that, in response to something you didn't know about. And we say that the fundamental point which underpins paragraph 7, fundamental flaw, is the same one that underpinned paragraph 6. It's that this is a mechanism which existed and operated independently of any overcharge. And so, if you ask the question, does this desire to cut costs and meet targets in any way arise out of the overcharge? Clearly, it doesn't. And absent the overcharge, the same mechanisms would operate and there will be the same desire to reduce costs and to meet targets. So in our submission, this discloses no causal relationship whatsoever.
Well, in order to establish a cause, I mean, the 7 is a complete non sequitur, isn't it? Because to establish a causal connection, you'd have to have a plea that, on the assumption that these were an overcharge, the effect of the cost targets was that the procurement staff did negotiate.
My lord, yes.
Otherwise, the whole thing is completely speculative. They would have done this, they would have done that, they might have done something else.
Indeed.
As you said a moment ago, they might have said to management, well, the only way you're going to deal with this is by reducing the advertising budget or something else.
There are many ways in which they could have responded. I use responded not intending to indicate that it would be consciously in response to
Which
an
would be a
overcharge.
classic example of res inter alias acta.
It would, my lord, yes, and so not to be taken into account.
Yeah.
And so, for those reasons, we say that this pleading has no realistic prospect of succeeding at trial because it simply lacks the fundamental element of causation, which is required for a viable case of mitigation.
So can I just check your response then? I was looking back at the submissions of Mr. O'Donoghue about, he says that FCA's business is a very particular sort of business with a very scrutinised approach to costs, and he showed us Mr. Stellantis' witness statement and so on. So he says it's not like other businesses. This business would have known exactly that their costs of bearings were increasing, and one way or t'other they would have dealt with it. What's your answer to that, as I understood his submission? Really very much based on the facts.
Well, I dare say, and yet we are faced with a pleaded case which identifies no concrete example of any response to the relevant costs at all.
So it's the causation point, isn't it? Maybe they might have noticed that they had increased costs, and they might have dealt with that, but you can't ally the response, the consequence with the cause. It's just they're like ships passing in the night.
Well, Lady, I say that all these cost steps, no matter how careful and thorough they were, are ones which are entirely independent of the overcharge. They would have happened in any event.
It'd be quite another if there was a pleaded case that, as a consequence of taking these of being obsessional about costs, your clients had actually discovered they were being overcharged.
My lord, indeed, that's
I mean, this is all. That's why I asked Mr. O'Donoghue the question whether it was his pleaded case. That you did know you were being overcharged, and it isn't. He can't say that.
no. There's no basis to say that whatsoever. That is, of course, one of the hypothetical examples that the Tribunal and Royal Mail identified, where you might well have that causal relationship if you had in fact identified an overcharge and responded to it. That would.
You might have a situation, I suppose, where halfway through the relevant period of time, you suddenly realise you're being overcharged, and before you get to the stage of litigation, or litigation being finalised, if you like, you've actually started taking steps to mitigate your loss in the way described. That's a completely different factual scenario. There you've got an obvious causal link.
My lord, indeed. From the point where that knowledge incepted, one might say, well, there you've actually taken steps in response.
The logical response to the cat's first example of what you might do, you wouldn't adjust your input costs if you discovered you being over, in other words, unlawfully charged. You'd simply issue proceedings or make a complaint, and that would bring you to an instant crashing halt.
Yeah.
One would hope so, yes.
Why on earth would you, unless you were up to no good yourself, why on earth would you actually try and adjust, go back to your supplier and say, actually, let's adjust costs? You just issue proceedings.
My lord, yes, that does make more sense.
Is that a convenient moment to break?
My lord, it is, yes.
2 o'clock.